Our guests today are Brian Breheny, a partner of Skadden Arps in Washington, D.C. He used to be the Deputy Director of the SEC's Division of Corporation Finance. Peter Kraus, who's Assistant General Counsel of Microsoft up in Seattle. David Kanarek, who's Vice President and Group Counsel of American Express in New York City. We're going to talk about the new business section of the Form 10-K. I'm Brock Romanek, today on Zippy Point. The business section, who would ever think we'd be having a panel about the business section of the Form 10-K? In all the years I've practiced, I've never seen any panel about it, but the SEC has made some rule changes, so it's a good time to revisit it. I should mention there's a separate webcast, a separate panel webcast. These are vid guides that I taped about the human capital management disclosures. That's something to watch after this panel, but this panel will not cover that topic, even though that is part of the business section. We're going to cover the other parts of the business section, which are just as important, even though human capital management is the hottest topic right now. So the first question for you, Brian, is what changes has the SEC made to the business section outside of the human capital area?
Okay, great. Good to be here with you, Brock, David, and Peter. Yeah, at long last, the SEC has gotten around to finally reviewing and revising the business section along with some other sections of SK and the 10K requirements. This is part of this disclosure effectiveness project, or whatever its variation it's been called over the years, where the SEC and the staff and Corfin in particular has been looking at finding ways to modernize and update the disclosure requirements. So in August of 2002, the SEC voted on a 3-2 vote. I'll leave aside the political nature of it, but nevertheless, it was a 3-2 vote to amend SK 101 in line with recent market developments and to improve the readability and to simplify the compliance requirements is what they characterized it as. And specifically, with regards to these requirements, which, by the way, went into effect on November 9th. So many companies missed this if you're a calendar year company for their third quarter Q, although if you are a non-calendar year company, there are some companies who have to comply early. So there's some examples out there. But nevertheless, coming up on the 10K for 2020, these are requirements that we'll need to think about and figure out how to comply with. So I'll break it down into sort of three elements. One, they amended the language itself of 101 to make it clear the company need only disclose the information that's material to the understanding of the general development of the business. I'm reading from the provision itself. In other words, the company no longer is required to address all this list of topics. If you've looked at a business section or your own business section, and you thought the company was a Delaware corporation, it was founded in 1905, and yada, 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 and you thought to yourself, why is that there? And then you went and looked at the old requirements and you thought, well, maybe it needs to be there, probably needed to be there. I think the SEC is now kind of telling you it doesn't need to be there anymore. You instead need to look at it and decide what is material to the understanding of the general development of the company's business. The amendments added a few topics, but again, they're non-exclusive list, including business strategy is one of those. And by the way, specifically, material changes to previous disclosed business strategy. So the commission was actually asked in the rulemaking process, do you need to provide some specific information about business strategy? The answer is if there's a material change. And then there's a list of other things like bankruptcies that the company may have gone through, some material mergers or consolidations or disposition of material amount of assets. But in a lot of ways, it's really sort of a principles-based kind of figure out what you think is important about your business. So that's number one. Number two, they eliminated the look-back period. You know, there used to be a 5-year look-back period that required you to specifically mention certain developments over a period of time. That's no longer there. You just need to, again, describe the general development of the business to the extent that you think it's material. And then finally, they added the ability to provide a hyperlink to information about the company's business that was included in prior filings rather than repeating that. That's a question that had come up at least when I was at the SEC, and since ways to find opportunities to streamline the disclosure by perhaps maybe not having to repeat certain information. So they offered the ability to provide a hyperlink. So that's a sort of general overview of kind of what's required now in the new SK amendments.
So Peter, do you think you need to start your business section from scratch this year because of these new SEC rules, or what do you think would be a common approach here?
I think that as I think about it, the approach that I think is good to take is not necessarily throw out the whole baby with the bathwater. I don't think you necessarily need to have a complete rewrite. You've probably got a lot of good content in there already. You might do it as a two-stage process. And one, you start with the process of elimination. As Brian said, there's some things that you no longer have to talk about, your year and form of incorporation, or maybe 5 years of the company history that aren't necessarily all that relevant anymore. So you could go through your existing disclosure and just kind of highlight the stuff that really doesn't speak to the company's current strategy and circumstances. So that's step one. But I do think it's an opportunity to take a really fresh look at the whole business section. Microsoft is an industry that is constantly reinventing itself, constantly a lot of disruption, and our business strategy and the nature of our business changed dramatically, I don't know, 5 years ago. So even obviously before this, we took a look at what we were saying to our board. We took a look at what we were saying externally to our investors. We look, internal conversations about strategy, and we said, our business section really isn't up to date anymore. And we just took a fresh scrub at it. And we used a lot of these materials that we were using already for the board and externally. So I think that's a good way to do it, is just to look at what you're saying about the business and take a fresh look at it. So I think it's a hybrid approach is the best way to go.
And Peter, on your first step of elimination, I too have rewritten our business section a couple of times now, and each time I undertake that process, what I've done is whatever I've eliminated, I put it into an inventory of deleted disclosures, if you will, and include that when I do my distributions internally, with the draft of the 10K, and then say, and here's what I've taken out. Please take a look at that list as well. Is there anything that you think should be retained? There's a lot of, I've found over my career, there's a lot of indirect uses for our disclosures, even beyond maybe directly what you might think of looking at the SEC rules. And so sometimes we brought back disclosures that I thought we could just delete. And so that might be a good practice tip.
So would those proposed eliminations sort of be like in notes on the same page, or like a separate document?
I've kept it as a separate document, but it depends on, you can have that as a comment box, or if you wanted to bracket it in the first draft as a mark for deletion. I think either one.
And David, who would you say should be involved in deciding the company's approach to what the business section should look like going forward?
Yeah, I think, piggybacking on what Peter has for his second view, which is take a fresh look. This is really an opportunity to just take a step back and describe the business without needing to frame the discussion around those specific line item requirements that Brian discussed. And so, who's in the best position to help you describe the business? I'd start with your other public disclosures. Look at how your company is describing itself to investors, what's on your website, in customer materials. You can look at recruiting guides and look at the proxy statement. There's a lot of good information and a lot of good narrative, I'm sure, that many companies already have out there. Speak with corporate communications, your investor relations colleagues. So you could go to senior management, but I have a sense that there's probably a lot that they've already said, both in the company and then externally, that you can use. So as I mentioned, I've done this a couple of times already, and this is a great opportunity to take a holistic view of your business without trying to look at your reportable operating segments, for example, in silos, and describe your business as you'd want to talk about it as a whole entity. On this non-exclusive list of disclosure topic examples, and in terms of who you're going to talk to, you really have to sort of, not just in the disclosure, but also in your rules check. I think there's going to be a little bit of thinking about who do you need to talk to within the company to get comfortable that you don't have, an additional disclosure you have to make. So it used to be easy, right? You said, do we have any customers that are over 10%? Okay, that rings the bell. Add in that disclosure. Here, you're going to have to ask about, for example, customer concentrations, but you might find Whereas before, a 9% customer, that was an easy, you don't have to add that in. Now you have to think about that a little bit more. And then conversely, if you have an 11% customer that you previously had to disclose, you might look at the facts and circumstances around that customer. Maybe they're in a long-term contract. Maybe there's other mitigating factors that you can decide not to disclose. So you really have to think about, for that form check, what kind of information do you need to bring into the process? Whereas you might have previously only asked about raw materials and intellectual property, the SEC has now expanded that to talk about resources material to the company generally. So who do you need to speak to for that? So I'd think about colleagues in the law department, operations, strategic initiatives, new product development, HR, and really pull in as much information. And if you're the drafts person, don't just pull that information thinking about for the business description. You can also use that, leverage that information that you're getting, apply it for how you're going to draft risk factors and other disclosures in your document.
Couple of thoughts, David. I wanted to pick up on what you said. One about the proxy statement, and I think that's really interesting because clearly our CDNA should be talking about what metrics we're judging our executives by, and that has a lot to say about strategy. So I think anything you say in the 10K about strategy should be consistent with the levers that you've got built into your compensation program. So I think that's a really important place to look. And then the only other thing I would add, David, is depending on how engaged your audit committee is, or maybe your audit committee chair, might be one place to go as well as you're rewriting the business section. You don't necessarily want to, if it's a significant rewrite, you wouldn't necessarily want to spring that on your committee or your chair a couple days before you're planning on releasing the K and get some negative feedback. So that might be a place to preview it as well.
And Brian, you mentioned strategy earlier. So is this a case where perhaps the letter to shareholders from the CEO starts to bleed into the 10K itself? What do you see in terms of disclosures about business strategy?
Yeah, I think that's a good place. One of the things I would look at. Look, I mean, the commission got some feedback, some comments, some suggestions they not proceed with this business strategy. And they also got a suggestion that companies have to provide an annual business strategy. And this response from the commission was like, no, we're not going to adopt that. It's principles based. And you only have to provide material updates to the business strategy. So it's possible that you may not see something on business strategy in every 10K. I mean, at least there's a basis for proceeding that way. And provided the company hasn't changed its strategy in a material way, you may not see some updates. So this may not be something you do every year. My guess is that's not what's going to happen. I suspect you're going to see an update to the business strategy. I think most companies are evolving, maybe not significant, in a very significant way. But I wonder if companies are really going to take the pass at trying to at least to update on an annual basis their strategy. There's no definition, Brock, of what business strategy means, and that was also raised as a possibility. And the commission said principles based. You go figure it out. There's some examples for people to look at. So it's going to be interesting to see what people think business strategy is. Although, as Peter and David mentioned, I mean, businesses are already doing this, of course. And so it'd be hard pressed to argue that you don't have a strategy, or at least what management sees as their strategy. So I think, this is going to be one of the items there's going to be a lot of thought put into this year. And I think it's kind of getting it right. And then I think once we see the host of annual 10Ks that get filed, people will probably look and think, oh, that's interesting. I didn't think about adding that, or I'll change it. And we'll start to see by variation. It's like somebody mentioned to me the other day about pay ratio. I'm like, oh, that's right. That's still on the books. I mean, remember how important that was? And I'm not suggesting it's not, but remember we all were like fretting it. And then all of a sudden, once you get it, you sort of get comfortable. I think strategy will probably fall into that. The commentators, by the way, one final thing, asked for a sort of safe harbor. Boy, you're asking me to put some forward-looking information. And in the release, they reminded you that the PCLRA and other forward-looking bespeaks caution language applies here. So to the extent that people are writing strategy with a forward-looking statement, you want to kind of make sure that it's covered to the extent that there might be liability attached to it. So they encourage you to draft it in a way to kind of give investors important information, and they're reminding you that to the extent that it would be. I'm not sure it would, but to the extent that people are concerned, make sure you get the protections of the safe harbor.
Brian, I'm curious about something in terms of companies that are looking at their IPOs. I've seen some commentary about the rules that suggest, well, maybe you should talk as little as possible about your strategy so that later on in subsequent filings you have less to update, and therefore you don't have to expose maybe sensitive strategies to your competitors. Do you think that's going to take hold? Do you think that's going to be kind of the common wisdom, or is there going to be other pressures really for companies undergoing IPOs to be very transparent about their strategy?
Yeah, and I wonder, Peter, if some of that is like as you're filing the materials, if they're public, many companies, as you know, get the ability to file confidentially. So maybe some of that's happening. So maybe the concern is to do it early, but I would be hard pressed to argue for lots of reasons: liability, marketing. If you're really trying to sell your securities, holding back on your strategy seems like the wrong way of doing it. Of course, they're probably these disclosures will be written in a way not to, to hold back perhaps some for minutia of the detail that could impact the strategy, I would say, but overarching, I would think that you would need to. And by the way, investment bankers who are, or as you know, buying the securities from the company as in an underwritten offering, they have their own sort of liabilities. I would think when you weigh all that out, I'm not sure I would suggest that that's probably the best approach. Not to say that people probably aren't talking about it, but I would think that the other concerns would override that, and ultimately you'll get some part of the strategy disclosed. Anyway, that's my thought. Interesting question, though.
So, Peter, when I started practicing, my first job at the SEC was in the group that oversaw the banking, the banks of the world, and the government regulation section of those 10Ks was pretty lengthy compared to the rest of the document. So now we have a rule change in this area. What do you see might be some of the changes there?
Yeah, as Brian mentioned, the rule on speaking about government regulation in your business section is not focused anymore just on environmental regulations, although that's clearly still there. But it's really this principles-based holistic approach of any government regulations that affect your capital expenditures, your earnings, your competitive position. So again, similar to what David and I were talking about in the general business description, I think it really behooves a company to look at not only its existing disclosures, but for instance, its risk factors. I mean, we talk a lot about regulatory risks and our risk factors, whether it's our history in competition law. Now we've got privacy, cybersecurity, artificial intelligence, trade, all of those things show up in our risk factors. So there's sort of an implication that we consider those significant, if not material. So I think you need to look at your risk factors. I think it's probably smart to talk to, if you have regulatory groups in your company who cover specific areas. Obviously, Brock, as you mentioned, there's financial services are heavily regulated. If you're in pharma, if you're in medical devices, if you're other heavily regulated industry, those are going to be top of mind. But I would suggest that even less regulated industries like tech, like retail, are really need to take a hard look at what's out there. What kind of litigation have you had in the past that have restricted your activities or subjected you to fines, and that are still on your radar screen? So again, I think it's really a holistic look. Be guided by the touchstone of materiality. Nobody wants a treatise on every possible regulation that could affect you, but it's clearly more than just environmental now.
Yeah, the risk of always going to other groups, of course, is they're in the group with that relates to that particular regulation. So for them, it's very important, and they'll probably want to have the 10K to be about it.
Yes.
So you got to always put your securities law hat on and with a dose of common sense.
Absolutely.
So David, what about the removal here of the 5-year look back requirement? How might companies decide whether to eliminate some of the older descriptions that they have had in the 10K?
Yeah, so first I think it's worthwhile mentioning that there's an interplay here with the Form 10K itself, which says to furnish the information required by 101 of SK, except that the discussion of the development of the business need only include development since the beginning of the fiscal year for which the report is filed. And the SEC put out a transitional FAQ on this, which really set it dead on that the new rules or the amendments to SK did not change that item in Form 10K. So outside of that nuance for 10K business description disclosures, say you were just looking at it broadly, just without the 5-year look back. And I think one way to think about it is what developments are still impacting the business. So, and this is the burden of a principles-based regime, but also a benefit. If you had a significant acquisition that occurred 4 years ago and it's been completely integrated, maybe not necessary to continue to disclose, but if you've got one that happened 6 or 7 or 8 years ago where you still have major issues lingering, like litigation, regulatory investigations, restructurings, that might be something to discuss. Same thing with major reorganizations or changes in your business operations. Startup company 5 years ago served one customer segment, quickly pivoted, and now they're going public, and they've been operating in 4.5 years with, very successful. Maybe not necessary to do the whole song and dance of what happened, at the beginning of time. But you may, want to provide a little bit more background if the history is relevant to how the company continues to operate. Think about, again, where your other disclosures are going to be in risk factors, legal proceedings, MD&A. Is this going to be a good place to introduce the fact that you used to be in a different business or you had a reorganization, because you're going to end up charting it back to it later on anyway.
And then, Brian, what about this notion of linking to previously filed information? I know this idea goes back, I'm sure, to when you were at the SEC. There's sort of the core document concept, and then you would link out. Personally, I'm a little bit dubious that companies will take advantage of this opportunity, but
yeah, I am too, Brock. I mean, I hope people do, and maybe it will take a while. I'm not sure I will see a lot out of the gate, but maybe over time. I mean, certainly when people do what I think Peter mentioned at one point, let me take a fresh look at my 10K. There are times when there's certain information that gets repeated because they think it's material to the understanding of the business. If you got to a place where you'd say, you know what, this section is always going to be there. It's important, but we have it someplace else. I think hyperlinking it might make sense. I think the other concern is, do you want it in the 4 corners of the document? Do you want people jumping from one document to another? And if you do jump to another document, you need to be careful about what's in that document. Are you somehow forward incorporating all this information? By the way, the SEC issued guidance in 2008, I think it might have been, on use of websites that talked about hyperlinking and how you can, limit your liability by describing exactly what it is you're hyperlinking, so that you can kind of narrow the focus. So I think with all of that kind of hair on it, my guess is that this is not going to take up a lot. People are just not going to use it as much as perhaps the commission had hoped, but maybe we'll see with time. Interested, I don't know what Peter or David, if they're thinking about doing it or what they think, but I haven't heard a lot of people, they're asking about it. What does it mean? All the sort of questions you asked, but I don't think we're going to see some early adopters. That's my gut.
Yeah, I think that there's a bit of hair on it, as you'd said, from double incorporation, what happens with the registration statement thereafter. My sense is one great use case is, for that company that just goes public, spend a lot of time on the business description in their S1, and then a few short months later, they're filing their 10K. That may be a good opportunity to just incorporate by reference what they had in their S1. That may be one reason where you do it.
The only thing I would add is kind of an analogy to risk factors, and we're one of those companies that chooses to repeat the risk factors every quarter in the Qs. And couple reasons for that. One is that we actually have a fairly robust quarterly process for looking at those risk factors and sending them out to a lot of stakeholders inside the company and getting feedback. And we don't always incorporate all that feedback, but at least we want to see it on a quarterly basis. We do a more thorough scrub for the Ks, as you would expect. But one of the things we think about is, if we didn't repeat the risk factors every quarter, and we did in fact have a new material risk that popped up in that quarter, then that would really be highlighted significantly and maybe overinterpreted when we put it in that one quarter. So I think sort of repeating it helps sort of bring the perspective to the whole thing and not have an overreaction to it. So I think similarly in the business description, if you repeat the full thing in your 10K every time, maybe changes and updates to your business strategy won't be overly interpreted.
Yeah, I like the idea of repeating it every quarter because that forces you to relook at it. Well, hopefully you're looking at the risk factors every quarter. I was always worried when I was in-house that the forward-looking cautionary language was not being updated, on the website as well as in the presentation. So I was really careful to do that. And that was even before some of the case law that came out that court, the judges said it's important that the cautionary language be updated and it's just not boilerplate from year to year as a factor. So Peter, you talked earlier about it. You might need to run a draft of the new business section by the audit committee chair. What about the independent auditors themselves? What role might they have in the new business section?
Right. It's not really their main focus of their audit, the way the financial statements, the notes, and even the MD&A is going to be. So at the same time, I think it's probably a good idea to keep them, up to date about changes and preview changes with them. I think, as David mentioned, and the issuing release mentioned, there are interplays between MD&A and the known trends and uncertainties that you're going to talk about in MD&A, and similar things that you might talk about in your business section and your update of your strategies. So, I think it's a good idea to keep your auditor aware of what you're doing and preview it for them and make sure you get comments, make sure you're not dropping any important content that they see. But again, it's not strictly part of their audit focus. David, I don't know if you have a different perspective on that.
No, I agree with that. They're a great resource just because they know the business well. Same thing with outside counsel, right? Just to get a good, clean read to make sure you didn't miss anything big or that you're describing it in the right way. So suffice it to say, in this environment, no matter what's going on with these rule changes, a lot of businesses have changed over the course of the pandemic. There's been a lot of business strategy changes. And so this is a good time anyway to just take a good, clean read of the business description, making sure that it's up to date. And maybe this is not the right time to avail yourself of incorporating by reference into a prior business description disclosure. Really think about where your business sits today.
So thank you very much. That was a robust discussion and I learned a lot. Have a good day.
Thanks, Brock. This was great.
Thank you, Brock.
See you, everyone.